Hello. Was the Supreme Court's decision about Roe versus Wade and Planned Parenthood versus Casey correct? In this short series, I intend to explore that question and share with you my decisions. In late June 2022, the Supreme Court voted 6-3 to overturn Roe versus Wade and Planned Parenthood versus Casey, which would result in the automatic overturning of over 20 others in the Dobbs versus Jackson Women's Health Organization 19-1392 case. This was brought to the Supreme Court by Mississippi and 25 other states. This decision has created a great deal of commotion from pro-choicers who feel that their rights have been tossed to the mercy of state legislators by an uncaring Supreme Court, and rejoiced by opponents of abortion, many of whom are conservative Christians. Previous to this, but not well known, was the passing of SB 8, a 6-week heartbeat law by the Texas state legislature. This law was upheld by the Supreme Court's 5 conservative justices in September of 2021. Handed down from the Supreme Court, many other cases have not acquired much public notice. Here are several that seem to deserve special attention. I don't know the story behind these cases or whether their decisions were valid, but I am concerned. Rivas Villegas, the court gave a cop qualified immunity for using excessive force. Tahlequah versus Bond, they did the same for a cop who killed a man. Zubaydah, they protected the CIA by allowing them to keep secret information about torture at CIA black sites. Valle Madero, Puerto Rican residents were denied Social Security benefits, which they do pay into. Cummings, they disallowed recovery for emotional distress damages in civil rights lawsuits. Patel, they stripped federal courts of jurisdiction to review fact issues in immigration proceedings. Egbert versus Bull, they stated that only Congress could authorize lawsuits against federal agents for violating constitutional rights, upholding the right of government agencies to conduct searches without warrants within 100 miles of the U.S. border. Is it time for you to move? Gonzalez, they denied long-detained immigrants access to a bond hearing. Biden versus Missouri, they blocked a federal vaccine mandate. Carson versus Macon, they undermined the Establishment Clause, forcing states to fund private religious schools. Castro Huerta, they undermined tribal sovereignty by making tribal land part of a state and allowing the state to exercise jurisdiction on tribal land, which is not surprising given the Americans' long history of violating treaties with the Native Americans. Brune, they struck down New York's 100-year-old restriction on concealed carry to expand 2A and limit gun restrictions. U.S. versus Texas, they allowed so-called bounty hunter anti-abortion laws. West Virginia versus EPA, they undermined the EPA's ability to regulate emissions and fight global warming. I guess they should be renamed the Sometimes Environmental Protection Agency. Shin versus Martinez Ramirez narrowed the scope of Sixth Amendment rights. A federal court can still hear inadequate legal representation claims, but can't consider evidence that wasn't already presented in earlier proceedings. My position. I have lived with the right to abortion, as well as other rights created under substantive due process since 1966, and I really wanted to discover if what they did was correct or even legal. I started researching this shortly after the decision, including talking to women who are pro-life, pro-choice, and have had an abortion. I have been surprised by the wide range of opinions, from the extremely conservative to the extremely liberal. However, I first need to be forthright with several facts about myself. First of all, I'm 55. I was raised in an anti-racism, equal rights amendment-friendly family, and I attended an anti-racism middle and high school. I was raised Protestant, but I am a deist. I was taught that women should have the same rights as men, and that men had long treated women as property for a long time, long time, which allowed men to do legally do horrible things to all women without repercussion in many cases. I also came to believe that abortion is a personal choice and that it should be the right of each woman to responsibly choose to have an abortion. Here are my thoughts on abortion. 1. It should not be used because the man and woman were too lazy or forgot to use contraception. Accept the consequences of your actions. It should not be used just because. I do not believe that the frivolous use of abortion is acceptable, and abortion has its consequences. And women should be made aware of the choices available to them and the consequences of each. Number 2, a heartbeat law is not acceptable because it takes 3 months for the fetus to be fully formed. In addition, it is still an embryo. A significant number of women don't even know if they're pregnant before that time. The baby doesn't even look fully human until the second trimester. Similarly, a quickening law, this is number 3. Similarly, a quickening law around 17 weeks when the movements of the baby are first detectable by the mother is not acceptable because it is not viable, which is to say that it isn't developed enough to survive outside the womb. Any baby that must be evacuated from its mother before 23 weeks will almost never survive, with the record being 21 weeks in a few days. And I think that's only happened once. That's been like less than 23 weeks. Although I understand the ancient underpinnings of using the quickening when the baby is first detected as moving as the boundary for abortion because it was the only way at the time to determine if the fetus was alive. I respect the decisions made at the time when medical knowledge was insufficient, but I do not at this time know of convincing reasons why that's when it should be the boundary. 4. To forbid abortion any later than the point at which a baby can be kept alive outside the womb at around 24 weeks, giving careful consideration to the financial burden and resulting stress in the home that the medical bill will cost, is acceptable. However, undue burden must be considered, and many scientific studies and loads of research have amply demonstrated the debilitating financial, emotional, and health consequences of ignoring undue burden for everyone in the family household. Still, if a woman dithers until the point of viability, I am convinced that she no longer holds the right to reverse her decision. Adoption should strongly be encouraged in such cases. I believe that abortion should always be legal in the cases of rape, incest, and serious medical reasons, including that the child will not live long and will be the cause of major mental health issues. But I feel that in the case of incest, adoption should be strongly encouraged instead. Both abortion and adoption should also be considered in other scenarios, such as whether the couple and their respective families either are unable to handle the financial and emotional responsibility, again, undue burden, or where being placed with either family would constitute a significant risk for the baby in terms of abuse, addiction, and the exposure to other deleterious situations that would result in a child that would have been better off being aborted than becoming a menace to society. You may not like it, but the statistics are very clear on this major risk. 6. Only medical necessity should be considered a valid reason for abortion after 24 weeks. 7. Refusing to allow the abortion of a baby from rape or incest during the first 24 weeks of its existence is the same thing as approving of the actions of rape and incest, and saddles the mother with a child she may not want or may even hate, thereby endangering the baby's life, health, and or mental health, and increasing the risk of the child either becoming a financial burden on society, becoming a criminal, or both. This is not to say that the fetus doesn't have the potential to rise above it all, but statistics support that the worse the environment, the greater the probability of negative outcomes, especially if the mother is single, living in a dangerous home or community, addicted to substances, living in poverty, or afflicted by disease or conditions that make employment difficult or impossible. 8. Abortions performed at a time in the fetus's development which would cause pain and suffering for the fetus beyond a second or so should not be allowed. Humaneness is still required, and, unlike a murderer in the death chair, a fetus does not deserve to be disposed of cruelly. Painless and humane methods of abortion must be developed and required for all abortions. Number 9, I also believe in abortion because I see no real effort from our country and people to improve our societal structure. Nor have I seen that our states and our nation are working to make major beneficial changes to create an artificial extended family where people help each other in times of trouble, such as unexpected and unwanted pregnancy, a natural disaster, famine, drought, and so on. To the contrary, I see a nation in decay that is being pulled apart by the struggle for unfettered profit. Number 10, I believe that the morning after pill should be allowed without a prescription and that it is both necessary and financially advantageous for insurance companies to pay for it. You cannot claim that getting rid of the zygote is killing a life unless you are basing your beliefs on religion, which is not an acceptable or provable excuse. Number 11, and the last one. Despite my personal feelings on abortion, I recognize that human nature being what it is, there will always be people who turn to abortion for unreasonable reasons. I also recognize that economic factors are a strong motivator because some families are destroyed by the financial and psychological changes, again, undue burden, wrought by the presence of an unexpected baby. If a baby is unwanted by some or all of the family, that baby can undergo horrible experiences, such as the ones that Eartha Kitt and many others went through. Some people will rise above it, but others will never fully recover. Now I'm going to quote from Determinants of Unintended Pregnancies in Rural Ghana, a 2014 study by Sebastian Eliasson, Frank Biden, Barbara A. Yankee, and Kofi Abusabo Asari, when it said, unintended pregnancies may carry serious consequences for women and their families, including the possibility of unsafe abortion, delayed prenatal care, poor maternal mental health, and poor child health outcomes. I hold that the well-being of a mother and the family unit is more important than that of just the baby. Now, the rest of the notes about me. We live in a pluralistic democratic republic, and as such, laws should not be based on religious convictions. In the case of conception, the man and woman should be held equally responsible for the baby. Engaging in sex carelessly, such as without using contraception, should result in you both accepting the consequences of your action. This is not to suggest that the couple must marry, however. I'm not so backwards that I believe in shotgun weddings. I would prefer that babies be given up for adoption to a loving family. I am not remotely close to a legal expert or a constitutional scholar. I reread the Constitution and Bill of Rights to make sure I knew their current state. Although the archives.gov website mentioned that there are other laws that may be pertinent to these and the Supreme Court, they were not referenced, and I did not search for them. Having made these clarifications so that you understand me and my stance, I want to also state that I will try to address this issue as fairly and intelligently as I can. Also, some people have protested that this decision disproportionately affects Black and brown families, but while looking at percentages alone gives the impression that a huge proportion of Hispanics and Blacks got abortions, the percentages don't consider the actual quantities of abortions. The fact is that the vast majority of abortions are done on white women. For example, KFF.org showed that in 2019, whites were at 33%, Blacks 38%, Hispanics 21%, and all others 7% in the USA. That sure makes it look like the non-whites were killing embryos and fetuses in huge numbers. Yet, if we consider the Census Bureau's data in ESTR 2019-SR11H, annual estimates of the resident population by sex, race, and Hispanic origin for the United States, April 1st, 2010 to July 1st, 2019, we can see that the real numbers for females are startlingly different. It's complicated because of mixed race people and the Census Bureau separating Hispanic so that it's not a race. I'm simplifying my information, and I'll leave it to the mathematicians to figure out more precise numbers. Just keep in mind that Hispanics include every race listed due to intermingling. Whites 33 million abortions. Blacks, 8 million. Others, which is Asians, Pacific Islanders, including Hawaiians, Native Americans, including Alaskans, and those of two or more races, 258,000. Hispanics, 196,000. So no, the myth of brown and black is not true. If you add up 8 million plus 258,000 and 196,000, that still doesn't come anywhere near 33 million. In fact, it's 4 times more white embryos and fetuses than all the others. How it started. This case started when Mississippi passed a ban on abortions except in a medical emergency or in the case of a severe fetal or abnormality, unless the estimated age of the embryo was greater than 15 weeks, called the Mississippi's Gestational Age Act, and that ban was overturned by a federal court 15 weeks later. That law constitutes a partial pre-viability ban. Mississippi went to the Supreme Court and requested that their law be allowed, stating that Roe v. Wade didn't need to be overturned. But this initial conciliatory approach of the 26 states involved only asking for the right to reduce their duration, was replaced when the Supreme Court agreed to take the case. At which point, those states demanded that the court either overturn Roe v. Wade and Casey versus Planned Parenthood, or grant the right to enact bans on pre-viability abortions. In other words, Mississippi wanted to have its cake and eat it too. Give us the right to violate the Roe and Casey precedents, or give total control over abortions by overturning those cases, which is almost the same thing. Ironically and foolishly, the states opposing those 26 states made an all-or-nothing demand, requiring that Roe and Casey be upheld or struck down. Pre-viability means before the baby can have a reasonable chance of success of surviving outside the womb, which is often considered to be 24 weeks. Although fetuses taken from the womb at that point have a 40% mortality rate and 40% will have health problems. It is only after 28 weeks that the fetus would have a strong likelihood of survival on its own. Unfortunately, the specialized care necessary may not be available, and it may be impossible for the mother to handle the costs. The lungs are not yet fully developed until near term, which is 40 weeks. Preterm births, anything before 37 weeks, account for about 1 million deaths a year worldwide. They are about 10% preterm births, which with risks such as lung, intestinal, and brain problems, and they may be developmentally delayed and have worse performance in school. Given the two stark choices, no wonder the Supreme Court conservatives were willing to strike down Roe v. Wade and Planned Parenthood v. Casey. Given that those same 5 justices had already ruled in favor of Texas's new, shorter duration for abortions, it was clear from the start who would win. Both sides are almost equally accountable for what happened. They damned Roe and Casey almost as much as the justices' predispositions did. 5 justices signed off on the reasoning and the judgment of Justice Alito. The Chief Justice disagreed with the reasoning, yet sided with them on the judgment to overturn Roe and Casey. The basic argument was that there is no explicit statement in the Constitution supporting the right of abortion, and the due process of the 14th Amendment, Section 1, does not apply to giving the right of abortion. The first section says, "All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. They also ignored stare decisis and referenced other court judgments to support their decision. Finally, they claimed that there was no history or tradition to support a constitutional right to abortion. Personally, I am confused why due process does not apply and why the previous clause mentioning life and liberty isn't mentioned. The majority references the stare decisis of Washington versus Glucksberg to guide itself, which said, deeply rooted in this nation's history and traditions, and implicit in the concept of ordered liberty. I didn't find that I understood the decision, and despite that I'm limited pro-choice, I strongly believed that I needed to understand this decision and discover whether or not the Supreme Court had betrayed their oath and duty. In the next video, I will share with you what I learned.